So what do this video and the person featured in it have in common? They're both making their grand debut today. Hey everyone, and welcome back to the channel. A couple of weeks ago on a live stream, I mentioned something that a lot of us in this community already know. If you picture a Venn diagram, the most entertaining place where those circles overlap is right in the center, where sovereign citizens and courtroom chaos meet. That overlap produces some of the wildest, most unpredictable, and unintentionally hilarious moments you'll ever see. And today's video is exactly that. We've got someone who fits squarely in that center zone. It's confidently delivering their own interpretation of the law while the court tries its hardest to keep things on track. Let's just say staying out of trouble requires more self-control than they were willing to demonstrate. So, with that said, let's jump straight into it. Title of the case.
Title of the case is People v. Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resist and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land.
Special appearance, you say? Interesting choice of words, because by the time we get to the end of this video, that label is going to take on a very different meaning. What starts as someone confidently declaring they're only present under their own special terms quickly turns into a situation where the court has a few terms of its own to introduce. And trust me, those terms have a lot more authority behind them. If there's one thing we've learned from watching these cases, it's that people who insist on making special appearances usually end up discovering that the court is perfectly capable of redefining their role, whether they like it or not. So buckle up, because this transformation happens fast. It's something you won't want to miss.
There is, and I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatch this plan. And I've offered that. I have the feeling she's going to take it today, but if not, I've got my...
Middleton's sovereign citizens seem to trust only the legal advice they hear from other sovereign citizens because, as the saying goes, birds of a feather tend to follow each other straight into the same problems. They reinforce each other's mistaken ideas, and the cycle just keeps spinning. Now, the prosecutor is about to present the plea offer, and let me tell you, this might be one of the most generous deals I've ever heard in a case like this. It's the kind of offer most defendants would take without a second thought. But not here because, in true sovereign citizen fashion, she rejects it outright. Of course she does. Accepting a reasonable deal would require acknowledging the court's authority, and that's the one thing she refuses to do, no matter how much it would help her. So instead of taking an easy off-ramp, she keeps charging forward, convinced she knows more about the law than the actual legal professionals in the room. And as you can probably guess, that decision sends this hearing in a very predictable direction.
He's offering to reduce the driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim. I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the...
It's a benefit. And
No, before that, about the license.
he's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit. He is offering to reduce the felony charge to a misdemeanor. And that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's just put on a
I'm not playing
prelim.
games. I'm serious.
You are playing games, and first of all,
I'm
you don't.
trying to advance to
All right,
what I'm
stop.
here
You don't
for.
interrupt the judge, whether you're a flat earther or not.
This plea offer is surprisingly generous. First and most importantly, the prosecutor is willing to reduce the felony charge all the way down to a misdemeanor. Second, he's agreeing to dismiss the separate misdemeanor she was already facing. And finally, if she manages to stay out of trouble for the next 6 months, that reduced misdemeanor, the one that used to be a felony, will be completely cleared from her record. To put it another way, she's being given the chance to walk away with absolutely nothing on her record, turning what began as a felony and a misdemeanor into a complete clean slate. Honestly, you almost never see deals this lenient. It's the kind of opportunity most defendants would grab and never look back. But Judge Middleton looks like even he knows this offer is extraordinarily charitable. You can practically see him hoping she'll recognize just how rare it is to get a second chance this generous. It's the legal equivalent of someone handing you a parachute. Right before you jump yet, you're still considering whether you want to wear it.
You're saying I've got very little patience for it. You don't have an attorney, which concerns me because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So, do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do
And
you
I-
want me to appoint an attorney for you, or would you like to represent yourself?
So may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a...
A flat earther, huh? Over the years on this channel, I've covered all kinds of baffling ideas and questionable decision-making. But there are only two groups who consistently take the cake when it comes to the sheer level of creative chaos they produce: flat earthers and sovereign citizens. Their confidence is unmatched. Their logic is, let's call it, experimental. And their belief systems are built on layers of misunderstandings stacked so high they could cast a shadow over reality itself. It's almost impressive, really, how far they're willing to push their own narratives. No matter how detached from reality those narratives become. The wild part is that they treat these beliefs as if they're profound revelations instead of what they really are: elaborate detours away from common sense. And somehow, the deeper they go, the more convinced they become that the rest of the world is wrong. So today's video brings us yet another example of that unique brand of confidence colliding headfirst with reality. And trust me, to ride.
case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court two types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these two jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. And I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed. And I would like it in writing, please.
The fact that the court even had the legal authority to ask you that question should be all the evidence you need to realize you're completely out of your depth here. Karen, when a judge has to explain basic jurisdiction to you in real time, That's usually a sign that your personal theories about the law don't hold up in an actual courtroom. But here's the thing. Some people insist on learning everything the hard way. Just like flat earthers only accept reality after running into contradictions they can't explain. Sovereign citizens often don't acknowledge jurisdiction until they experience its consequences firsthand. And in this case, that means discovering that the courtroom doesn't operate on personal beliefs, it operates on actual legal authority. So, while it might be frustrating to watch someone ignore every warning sign, sometimes the only way for them to understand how the system works is to go through the process themselves. And by the end of it, the courts always make the lesson unmistakably clear.
Procedure is criminal procedure, and the defendant doesn't come up and show, "Court, tell me why I get to do this." You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report bond information that I came with the file. So, what would you like to do here today? Do you wish to represent yourself?
Thank you. I do. I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All right,
under
stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's
procedure.
the Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop.
Criminal procedure practically begs for a moment of silence after everything you just unloaded on the court without so much as a warning. You requested a written copy of the Michigan Civil Rules of Procedure, which are publicly available online under Chapter 2 of the Michigan Court Rules. But even if you track them down, they won't do you any good here because this isn't a civil matter. You're not in small claims court. You're not in a contract dispute. You're in a criminal proceeding. And that means the rules you need to be looking at are found in Chapter 6 of that very same publication. Those are the rules that actually apply to your situation. And they outline everything from arraignment to trial to sentencing. So while it's nice that you're trying to familiarize yourself with court procedures, understanding which set of rules applies is step one. And right now, you're flipping through the wrong textbook for the class you're in.
And you're going to go to jail.
Objection, please.
All right, please.
Please.
We're going
sir,
to talk
may
about
I-
this
the
tomorrow
contempt.
at 3 o'clock. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be
right
held in
now,
contempt,
and we
sir.
will. Well, you have been.
I'm simply
This matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock, and you will be more respectful to the court.
I
You
can
will speak.
provide the
You will not interrupt
citations.
the court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
Do you wanna
with the
continue?
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We will address this tomorrow at 3 o'clock.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
I'll be more than happy to. She's going into custody for contempt.
Let's go this way.
If I were in your position, I'd seriously consider staying quiet for a moment. Because Judge Middleton has made it perfectly clear he isn't entertaining any of your usual antics today. Every time you interrupt, argue, or try to steer the hearing off the rails, you push the judge closer to exercising the authority he absolutely has. And your struggle to simply remain silent when instructed is putting you on a very fast track towards spending the night in custody. This isn't a debate club. And it's not a forum for personal theories about the Litza courtroom. Judges expect order, respect, and basic cooperation. And when someone refuses to follow those expectations, the consequences show up quickly. And right now, you're inching closer to learning that lesson first.
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that. But,
Well, I told her to stop, and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's going to contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock, and to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admin law.
Some of you may have caught it when the prosecutor mentioned that her son was also present in the courtroom. Well, it turns out he follows the same sovereign citizen philosophy she does. And Judge Middleton, seeing both of them there together, decided it was the perfect moment to address him directly and make sure he understood exactly how the law actually works. He didn't raise his voice. He didn't get dramatic. He simply laid out the facts with a kind of calm authority that only a seasoned judge can deliver. And let's just say it was a reality check that he probably wasn't expecting, but absolutely needed.